Good evening, all. I, Chaitanya Bansal, on behalf of Team Corporate Law Advisor and CII, welcome you all to today's session of live channel on ADR laws. Today's session is divided in two parts. In the first part, our expert will discuss the latest judgment delivered by Honorable Supreme Court and Delhi High Court. In the second part, our experts will conduct a panel discussion on an interesting topic, that is decoding the proposed amendments to e-commerce rules. The updates will be discussed by Vishwam sir, who is a dual qualified lawyer having a vast experience in international arbitration and online dispute resolution. For panel discussion, we have with us Akshay Hegde sir, Vinita Varghese ma'am, and Pandurang Acharya sir. So, before we begin with this session, I would like to request all participants to please be on mute. During the session, if any participant has any query, feel free to post it in the chat box and they will be duly answered. With these words, I now hand over the dice to Vishwam sir. Thank you.
Thank you, Chaitanya. Hello, everybody. Good evening. I hope everyone is staying well. I will just sort of dive right into it like we do always. So for those of you who've joined the webinars before and have been keeping track, like Chaitanya said, there are sort of two sessions or two blocks in the webinar. The first one is the update session. So the first one is the update session, and then we've got a very interesting panel of experts lined up to discuss the e-commerce rules. They've been in the news for a while, so hopefully we'll have a good discussion today, which everyone can learn something. In terms of updates, we've got 5 decisions. This month has been actually quite heavy on the Delhi side. So you can see 4 Delhi High Court decisions and 1 Supreme Court decision. I think generally we've had more Supreme Court in a mix of sort of Bombay, Delhi, and other high courts. It just so happens that today I think it's a little more Delhi heavy. But I'll dive right into the first case. Just like the usual sort of house rules we follow. If you have any questions or if anybody has any thoughts or any experiences they want to share, please feel free. And probably the best way would be after every case I finish during the update session, we can take questions, comments, thoughts at that time before I move on to the sort of next case. So the first case is the Haldiram Snacks Private Limited versus Mega Enterprises. The issue here before the Delhi High Court was what is the scope of patent illegality on Section 34 of the Arbitration Act. So there's obviously been, loads of jurisprudence in Section 34 and challenge and annulment proceedings. We've discussed some of that in great detail in our previous webinars. I specifically remember, I think, the February and March webinar. Today, we're not going to discuss too much of 34. I'll keep it limited to just the decisions and what the Delhi High Court has decided, because I want to have sort of more time for the panel discussion. But the factual background in this case was that Mega Enterprises and Coral Enterprises, which is now part of the Haldiram's group, they had entered into 2 high seas agreements for the sale of oil. And essentially what happened was that the possession of oil was transferred from Mega to Coral. And then there was subsequent communications exchanged, but there was actually no payment for the oil. And there is a limitation issue. So for instance, the last invoice which was issued was 25th of February 2013. The payment was then due on the 7th of March, but there were references to payment and communications as late as sort of June 2013. And Haldiram's only invoked arbitration in May 2016. So there was a massive dispute about limitation before the arbitrators. Mega argues that, its remedy is barred by limitation, but in the end, the tribunal dismissed the limitation bar claim and an award was issued in Haldiram's favor. So Mega then filed a Section 34 petition in the Delhi High Court. In terms of the submissions, the petitioner basically Mega alleged that there is patent illegality because firstly, the proceedings were barred by limitation. And then the emails used by the tribunal did not have certificates which are required in Section 65B of the Evidence Act. And basically, because of this, the tribunal had misapplied Section 18 of the Limitation Act because there is no evidence. So, the tribunal should not have considered evidence which did not have Section 65B certificates which are required by the Evidence Act. The respondent, on the other hand, argued that the Evidence Act is actually not applicable specifically to arbitration. So arbitrators don't really need a Section 65B certificate to decide if the evidence is admissible or not. And respondent did say that the documents were admissible and even the Limitation Act was interpreted properly. So the interesting question the Delhi High Court decided under Section 34 is what is really the threshold of patent illegality to successfully annul an award. And the High Court said that the tribunal must be acting arbitrarily or capriciously, and merely because an arbitrator disagrees with what the High Court said, whether it's in terms of a certificate under Evidence Act or whether it's just a different interpretation which the High Court would have taken, that is not sufficient to basically attract the patent illegality test. So it basically said, not requiring certificates or applying a different interpretation than what the High Court judgment gives could potentially be wrong in law, but that is not really considered arbitrary or capricious under the Arbitration Act. So you can't really annul an award on that basis. And then the High Court goes on to say that limitation only bars the remedy. It doesn't really extinguish debt, which is why the award is not really against fundamental public policy, because it doesn't actually go against justice or morality or in any of those fundamental principles. So probably an important decision in terms of, what constitutes patent illegality. There's been lots of jurisprudence, like I said, we've discussed. But it is quite interesting to see that, if you're wrong in law and if you've completely disagreed with what the High Courts have said previously, or even the Supreme Court said previously, that is not really a sufficient ground to challenge an award under Section 34 when you argue patent illegality. So that's the end of the first case. If there's anybody in the audience which has any questions on this case, or if just any lawyer or arbitrator or anybody wants to share any experience they've had on similar issues or they've dealt with cases, I think we can do that now before I move on to the next case. No, okay, I'll move on to the next case. Next case is also a Delhi High Court decision. Savitri Jain, sole proprietor of Navalka Sales versus Krishna Packaging, decision rendered in April 2021. This was a Section 9 application for interim relief. There was an appeal against the trial court order which had dismissed a Section 9 application. We've got one more case today discussing Section 9, so we're going to discuss two different aspects of Section 9. But in this case, the respondent's ledgers, so there was a dispute about payment of debt. The respondent's ledgers did actually show that debt was owed to the appellant, and the arbitration proceedings were basically commenced to recover the debt. Section 9 was filed by the claimant or the appellant to stop the respondent from alienating certain other property, so the award could finally be enforced against the respondent. So before the Delhi High Court, the appellant argued that the debt is admitted because it's actually shown in the respondent's balance sheet, which prima facie is a reason why they should get interim relief under Section 9. So the appellant didn't prove any urgency, didn't prove the 3 factors or the 4 factors you have to prove for getting an injunction. All they did was say, the debt is admitted and it's a prima facie admission, which is why we deserve interim relief under Section 9. The respondent, on the other hand, did say, they've not really proved any urgency. They did also dispute the fact that there is debt on the balance sheet saying it was subject to conditions and it's not really unconditional and absolute debt. And they basically said, an appellant has not shown how the respondent is alienating its property or doing anything which would make the arbitration infructuous. So very interestingly, for Section 9, the Delhi High Court said that firstly, balance sheets do reflect prima facie an acknowledgement of debt, and you have to take them on their face value as being true and correct. Secondly, they went into the jurisprudence of sort of orders 38, 39 and the powers that court have there vis-a-vis what the court has under Section 9 for granting interim relief. And the court said that one of the primary goals of the court under Section 9 is to ensure that the award is executable, so the proceedings do not become infructuous. So the Delhi High Court basically awarded interim relief under Section 9, saying, because there's a prima facie acknowledgement of debt, you're entitled to relief under Section 9. It doesn't matter whether it's urgent or not. So I guess some would say slightly, different from what the jurisprudence has largely been for Section 9. Some would say not really, but I think quite an interesting decision issued by the Delhi High Court there. Again, I think that's the end of this case. So if there's any questions, comments, thoughts anybody has, on this case, we can take them now. Okay, then moving on. Also, Delhi High Court decision, the Airport Authorities of India versus Bentwood seating system. What I've done is I've used the initials for Airport Authority of India, AI, and BSS for the respondent. So the facts were basically, the Airport Authority had issued a purchase order in favor of BSS, which was a purchase order and a maintenance contract as well. That was then terminated by the Airports Authority of India on account of delays by the respondent in completing the supply, but they did not give any reasons allegedly. So this was then challenged in arbitration proceedings by Bentwood Seating System, and there was an award in favor of Bentwood Seating System. The arbitral proceedings, so before the arbitrator, there was a claim of fraud, which in the end, in the award, it was not properly decided. And the reason the court said it was not properly decided, or the reason the appellant argued, the Airport Authority argued, was that there was no reasons given on the tribunal's decision on fraud. And fraud was sort of inexplicably linked with, again, a certificate not being provided under Section 65B of the Evidence Act. So there was, challenge petition before the Delhi High Court on Section 34. The arguments made by the Airport Authority was that, there was a fraud claim. Fraud claim is a fundamental claim for any arbitration. The arbitrator did not decide it, did not consider it, and hence the award should be set aside. The respondent, Bentwood Seating System, which is also the award creditor, argued that the tribunal had not accepted the claim of fraud, which the Airport Authority alleged, but it was definitely considered. So the tribunal, has included it in its award, whether they've given reasons or not. They have. It's been considered. It's been dealt with on merits. And then Bentwood took the stand that, in any event, this is a curable defect. So if the High Court were to think that, if this is an issue that the tribunal has not dealt with, the award, you don't need to set aside the award. Proceedings can resume. You can send the decision, the award, back to the arbitrator. They can look at the fraud claim again, or amend the award to include reasons for the fraud. And then that's the best remedy. There were other arguments going into, whether the arbitrator had jurisdiction in the contract for certain issues, but I'm not really covering those for our purposes. So very interesting, the Delhi High Court said that, fraud was actually one of the main claims before the tribunal, and the tribunal must address whether the claim is accepted or rejected with reasons. So in the award, the tribunal did reject the fraud claim, but there were absolutely no reasons or no, consideration on merits. And the High Court said that this is an incurable defect because, firstly, it is a serious allegation. It can render the contract voidable under the Indian Contract Act. And this can actually fundamentally change the reliefs awarded by the tribunal, whether that's to Bentwood Seating System or Airport Authority of India. So the award was set aside in this case. So again, this is the second Section 34 case that we have for today. Any questions, any comments, any thoughts on this case or the the three cases that we've dealt with? No, okay. The next case is again a Delhi High Court decision, the Navyuk Bengaluru Tollway versus NHAI. This is the second Section 9 decision that we're discussing today. But basically, Section 9 application was filed by the Navyuk Bangalore Tollway, seeking about 90% of the debt owed, which is basically claiming from NHAI in an arbitration, saying, you put in an escrow account, and that was the interim relief they asked the Delhi High Court. The factual background is that there were two agreements. One was a concession agreement for a highway development and maintenance project. The construction actually finished back in 2010, and Navyuk was collecting toll for almost 10 years till 2020, after which the concessionaire was terminated by NHAI. The second agreement was the loan agreement. That was a tripartite agreement between lenders, mostly public sector banks, Navyuk Bengaluru and NHAI. And Navyuk basically alleged that NHAI was in breach of this agreement. So Navyuk was alleging that NHAI is in breach of the loan agreement, and NHAI was arguing that Navyuk is in breach of the concessionaire. So basically, the contracts were terminated, and there was a dispute about what the debt is or how to quantify the debt as well in the arbitration. So essentially what happened in terms of urgency was that Navyuk started getting letters from public sector banks saying if they don't pay up, they're going to be declared as an NPA. And Navyuk was quite concerned about its reputation and creditworthiness, once it's declared an NPA. So, and NHAI has all along sort of been collecting tolls since February of this year, and they've not really given any guarantee on payments to Navyuk. So Navyuk basically came to the Delhi High Court for Section 9 relief. The arguments that Navyuk made was, the urgency, they said, is that they don't want to be declared an NPA because then that affects their creditworthiness and reputation in the market. NHAI basically didn't defend the urgency as such, but they said that, what Navyuk was really asking for is a sort of final award in Section 9 proceedings, which it cannot do because, remember, they're asking for almost 90% of the debt owed. NHAI said, debt is actually only going to become due in September 2021. And prior to the termination, defects were curable, but were not cured by the parties. So then the High Court basically agreed with NHAI, and they said a party cannot be granted interim relief that is in the nature of final relief, even if there is urgency. So Section 9, I guess, you have to be very careful on what you're asking for relief. Irrespective of whether there is urgency or not, your relief needs to be very specific and not something that you would actually get in an arbitration, for instance. And the court basically said, 90% of the alleged debt would require the court to fully examine the facts and interpret both the contracts. But under Section 9, they can only do a prima facie evaluation. So essentially, that's the Delhi High Court decision. Again, any questions, any comments, any thoughts on this decision before we move on to the final decision? No, okay. The last case is actually quite interesting, and it's been in the news, I think, for almost a month now. This is from the Supreme Court to Judge bench. Silpi Industries versus Kerala State Road Transport. That was one case, and the other case was Khayati Engineering versus Prodigy Hydropower. So the Supreme Court basically decided both cases through a common judgment because the issues were identical. So I'm going to take you through the facts of both cases, slightly similar, mostly similar, but slightly different. And this case concerns the MSME Development Act of 2006. So there was a contract executed between Silpi Industries, which is a seller under the MSME Act, and KSTC, which is a buyer under the MSME Act. Standard contract for supply, in which the seller was to receive 90% payment up when the goods are supplied and 10%. They were subject to a final performance report. Khayati, again, a contract between Khayati, which claimed to be a seller under the MSMED Act. So it's not really a seller, and I'll come to why that's the case. And PHP, which is Prodigy Hydropower. So this was basically a contract where seller awarded for supplying and installation of equipment. A contract was performed, but the buyer refused, saying there's been a breach. So in the Supreme Court, both the sellers were the appellants. So the initial proceedings before the Supreme Court, as you know, under the MSME Act, there is a facilitation council and other competent authorities which you can approach if you're an MSME registered company. So Silpi approached the facilitation council and initiated conciliation proceedings. They failed, so they went to arbitration under Section 18.3 of the MSMED Act. For those of you who are not familiar, Section 18.3 of the MSME Act basically says, that if conciliation proceedings fail before the council, you will have the dispute resolved in arbitration, and then the Arbitration Act applies. In the arbitration, the Kerala State Transport raised some counterclaims, and the arbitrator issued an award, which was actually then set aside by the Kerala High Court for fresh adjudication. And I'll come to what the issues are later. But in the Khayati also initiated conciliation proceedings. Prodigy Hydropower initially appeared before the council, but then it actually filed an application under Section 11 of the Arbitration Act, claiming that the MSME Act is not applicable. And the reason they said that was because Khayati was actually not registered under the MSME Act when the contract was executed. They became an MSME, a registered MSME under the Act much after the contract was executed between the parties. So they said that MSME Act is not applicable, which is why they went under Section 11 for the appointment of an arbitrator. But basically, they went to the Madras High Court, which had allowed the application and appointed an arbitrator. So there were appeals now to the Supreme Court. So two issues. The first is, whether the provisions of the Limitation Act is applicable, firstly to arbitration proceedings, which are under the MSME Act, because there were issues of limitation in the cases. And the second is whether counterclaims is maintainable in arbitration proceedings under the MSME Act. So just to sort of take a step back, for those of you not familiar, MSME Act is actually quite seller friendly. They have a number of provisions which protect the sellers, keeping in line with the policy of MSME, which has been issued by government from time to time. So the sellers were basically arguing that, we can initiate proceedings, but the buyer actually cannot counterclaim anything because the buyer is not defined as a party under the MSME Act, and there are no protections to the buyer. So that was one of the main submissions. And the other submissions were that, there is no Limitation Act applicable for arbitration proceedings commenced under the MSME Act. So the submissions, the appellants argued that, the MSME Act was to promote certain enterprises, like I said, and Chapter 5 suggests that proceedings can only be brought by suppliers. So proceedings cannot be brought by buyers, so there cannot be any counterclaim. And there's absolutely no jurisdiction that the arbitrators have in respect of any buyer's claim in a proceedings initiated by the seller. And they go on to argue that, parties in Section 18 only refers to supplier actually. So the respondents, which is the buyers, said, if they cannot counterclaim, then the act basically becomes OTRs. It's got no practical value, because what then potentially you're doing is you're opening the floodgates for disingenuous sellers to block buyer remedies and just initiate proceedings and get relief, whether they deserve the money or they have a right to claim the money or not. And they said legally, the MSME Act basically says that proceedings are subject to the Arbitration Act, and the agreement is subject to Section 7(1) of the Arbitration Act. So to that extent, there is no reason to bar filing of counterclaims, which is permitted under the Arbitration Act. So the Supreme Court said that they agreed with the buyers on both points actually. On Section 18, so they went into the sort of jurisprudence of Section 18 and said that Section 18 is pretty express in terms of the fact that the ANC Act applies. Now, if the ANC Act applies, it applies in totality. And as you know, ANC Act has Section 43, which says Limitation Act will apply to arbitrations. And they also referred to an earlier decision of 2015, so 6 years ago, which says that Limitation Act is applicable to the MSME proceedings. For those of you who've been attending webinars regularly, we've actually covered a number of decisions, quite important decisions and landmark decisions, I think in our last two webinars, on how limitation is calculated differently across different stages in arbitration. So the Supreme Court said, it's Limitation Act applies to arbitration under the MSME Act. Then they referred also to Section 23(2)(a) of the Arbitration Act, which basically says that, respondent has a right to submit a counterclaim. And if the respondent actually does not submit a counterclaim, then what this opens up is potentially parallel proceedings and potentially conflicting findings by different forums, which are listening to the matter. So basically, they decided in favor of the buyer on both accounts that Limitation Act applies and counterclaims are admissible. It doesn't really matter whether the proceedings were initiated under the MSME Act to begin with. Interestingly, they also said, that MSMED is actually a special statute, whereas arbitration is a general statute. And even if an agreement actually does have an arbitration clause, a seller, which is a registered seller under the MSMED Act, can first go to the competent authorities, so whether that's the Facilitation Council or other authorities, make a claim, and thereafter go to arbitration if the conciliation proceedings fail. I think quite an important decision actually. because this potentially affects, has a potential to affect a large number of contracts where the MSMEs are registered. They could potentially look at, delaying arbitration proceedings by first going to facilitation councils for conciliation and only then move to arbitration. Very interestingly, in the second case, Khayati, like I said, the MSME Act, the Supreme Court said did not apply because Khayati, which is the seller, was not registered as an MSME with the government on the date of the contract. And the High Court said you should be recognized and registered with the government when you enter into the contract. You can't enter into the contract, supply the goods, then get registration and claim benefits under the MSME Act. Doesn't apply, it doesn't work that way. You have to be registered before the contract is signed. And they basically said, Khayati is not entitled to any of the benefits under the MSME Act. And the High Court was actually right in appointing arbitrator under Section 11 of the Arbitration Act. So again, I think what findings we see here potentially will have massive, consequences for MSMEs. Firstly, because I was reading some stats to actually show that, only 10% MSMEs are actually registered with the government. So all the unregistered MSMEs expressly will not be having any benefits that the MSME Act provides. And if you've looked into the MSME Act provision and studied jurisprudence, there are actually a number of high court decisions, sometimes conflicting, which do say that unrecognized or unregistered MSMEs will also get the benefit of the Act. But I think this decision will basically clear the air on that and say, if you're not a registered MSME, you don't get the benefit, which actually means 90% of the MSMEs in India today, which are not registered, will not be able to claim the benefits of the Act anymore. So it's quite an important decision actually for MSMEs in arbitration in general. That's the end of this decision, and actually that's the end of our update section as well. I'm going to go back to the update slide in case anybody has any questions, any thoughts, any experiences they want to share, anything really. I think we can discuss them now. Otherwise, if everybody is just waiting for the panel discussion to start, then we can jump right in. Just going to maybe wait for like 10 seconds. Okay, perfect then. So today's panel discussion, like Chaitanya mentioned in the beginning, we've got a very impressive panel, and we're going to discuss the proposed amendments to the e-commerce rules, which the government had invited sessions for. I think the last date was 21st July, so it's gone. We'll have an interesting discussion now, and then I guess we just wait and watch and what the government decides. But without further ado, you can see we've got a very impressive panel of experts, and I would request Chaitanya to just introduce the experts once.
Thank you, sir. So, participants, for panel discussion, we have with us Akshay Hegde, sir, Vinita Varghese, ma'am, and Pandurang Acharya, sir. Akshay, sir, is a graduate in industrial engineering from Purdue University and is the co-founder and managing director of ShakeDeal, India's largest B2B e-commerce marketplace, which makes procurement of industrial goods and other supplies easier. He has demonstrated expertise in distribution, warehousing, logistics, and network optimization. Vinita ma'am is a corporate commercial lawyer with an experience of more than 11 years. She is presently leading the legal function of Urban Company India and its global operations in the Middle East, Singapore, and Australia. In the past, she has managed the core operations of Ola India and UK and advised the company on day-to-day operations of aggregation business, compliance management, government alliances, and other aspects. Prior to that, she was in private practice with Baker McKenzie and Clifford Chance. Pandurang sir is a corporate lawyer with more than 17 years of experience in the field of e-commerce, real estate, telecom, and other fields. Presently, he is working as the General Counsel at Girnar Soft. In the past, he has served as AVP Legal at Swiggy, Senior Legal Counsel at Flipkart, Deputy Legal Manager at Videocon Telecommunications Limited, and has also held other key positions. The session shall be moderated by Vishwam sir. And again, I tell you that if any participant has any query, feel free to post it in the chat box and they will be duly answered. With these words, I now hand over the dice back to Vishwam sir. Thank you.
Thank you, Chaitanya, and welcome all the panelists. Uh, I'm going to just sort of start from a very, I guess, broad question, just taking a step back. We've seen the definition of e-commerce entities being expanded. Whether the changes are, do they make a big impact or not? Let me come to you, Vinita, first. Can you tell us first what is the change in the definition of e-commerce entities and what impact does it really have, whether it's in the Indian market or even international markets which are trying to service the Indian market as far as e-commerce is concerned?
Sure, Vishwam. So just to give a flavor of what it was before these recent amendments, an e-commerce entity was simply a person who owns, operates, or manages a digital or electronic platform for the purpose of e-commerce. Now that simple definition has now been made more nuanced. Certain elements have been introduced to the definition, which has expanded the scope of the rules themselves because they apply to all now the new defined e-commerce entity. What it has done is it has included that any entity which is engaged in the fulfillment of orders placed by a consumer on the e-commerce platform will also form part of the e-commerce entity definition, as well as related parties under the Companies Act, which means the ambit of the e-commerce entities covered under the new rules has widened exponentially. How these will impact the actual workings of each entity is something that we will have to look at and see how far this goes, because every entity, every e-commerce platform will have different modes of fulfillment. While the rules do at some point refer to logistics providers and what their regulations will be, however, there are various players within that ecosystem who help in the fulfillment of an order, from let's say even a call center to a payment provider. The question is whether all of these players in that ecosystem, from cradle to grave of a platform order or delivery, will now become e-commerce entity, or will it still be a question of whether they themselves are in fact online platforms at all, or will a brick and mortar facility provider will get covered under the regulations as they stand today? So that's something we will have to wait for clarity on, and to understand what impact which entity in the flow will have to suffer or comply with. In addition to that, the Companies Act definition of related parties in itself is also fairly wide, by virtue of the fact that the Companies Act obligations are built in a fashion to cover certain entities for compliance matters. When it has been now transposed into the e-commerce rules, that impact is now on directors. I mean, I won't bore the panel or the audience with the definition, but it includes a variety of players in a company, from a director to everyone else who you would, and I'm sure everyone's familiar with the definition. So again, a bit of a question mark there as to how this will, one, impact a platform which is giving consumer activities or products. Also, how obligations will be hitched onto each of these players who now come under the related party definition. Another interesting nuance is that in addition to related party, the rules also refer to associated entities in certain sections, which is even broader, even wider, and not entirely, there are no four corners of that square as to who will fall within that definition. So that's something which is to be examined and to be understood as to what the impact will be. So that's the basic change in the definition. With regard to how this will impact foreign entities, again, at the moment, it is very difficult to assess, right? Because even if there are foreign companies operating in India today, providing online services or goods to consumers, they continue to be registered in one form or the other. Will mere registration with the DPIIT change anything? Perhaps unlikely. Will the registration now come with its own set of compliances? That may have an impact on how foreign entities play out in the market. So that's a small gist of that. Any specific questions on this, or you want to take this.
No, that's very helpful. I think that sets the context very well. I'm going to come to you now, Panduranga. What do you think is the impact in terms of how this is going to play out in the market? And can you give us like any example at all, like what companies say would not have been an e-commerce entity before, but is probably now an e-commerce entity?
So is this question to me?
Yeah.
Oh, sorry, I was just losing the. Hey, hi. Thank you, Vishwam. Thanks, Vinita, for setting it up nicely. And welcome all the participants to this session. Vishwam, if I may correctly understood what your question is, like, who are all excluded from this definition of e-commerce?
No, I'm just trying to understand like what companies say were not e-commerce companies earlier, but now they would be under the new definition. And what do you see as the impact? We've heard from Vinita in terms of what she thinks the impact is. I'm just like keen to hear what you think about it.
Okay, there is bit of a confusion which is crept in this amendment proposition. And if you were to ask me, like, there was inherently confusion in the rules. I think most of these terms were simply borrowed from the FDA policy and the FEMA regulations, where marketplace and the marketplace and inventory-based model of e-commerce is recognized. Now, e-commerce should have been an umbrella for all these kind of various methods of e-commerce transactions on India or elsewhere. Now the kind of definitions and what they are trying to do is little confusing for me, and so the reason being, generally those companies who were e-commerce companies earlier will still remain e-commerce companies, and whoever have not associated with e-commerce companies don't have a risk of recognized as called as a e-commerce company. But there are chances of few entities who have been part of this entire supply to electronic commerce could be at a risk, because unless it is identified, like logistics service provider is identified, defined. Now they should be happy, at least they were defined, therefore they are no longer e-commerce entity. And I read the definition under section 3B, which says means any person who owns, operate, manages digital or electronic facility or platform or electronic commerce, including any entity engaged by such person for the purpose of fulfillment of orders. Now, fulfillment is for the fulfillment purpose. These e-commerce companies would have to look up to a logistic company. Now, logistic companies were called out, defined separately as they are logistic companies, so that they should be like feeling happy about because they are no longer a e-commerce entity, or should they feel sad about because they've been engaged by these e-commerce entities. And any related party under the definition of the Companies Act, which is very wide, but Vinita has explained. Thankfully, they have not mentioned associate companies here, right, and other related companies. But they created a carve-out, but does not include a seller offering his goods and services for sale on a marketplace e-commerce. I really lost my mind. To understand this is something very difficult for us to gather, like what they are trying to say here in this language. So in true intent, I see there is they have a good intent to deal with certain problems that e-commerce consumers are facing, but I think mostly they are getting overly into the businesses and trying to understand them, which is, I think, they are not good at. I think they should not. This is what I felt about it.
Okay. Thank you, Panduranga. I'm going to move on just in the interest of time. I'm going to come to you, Akshay. There's been a lot of news about sort of fallback liability, impacting e-commerce companies now. What how do you look at that, and what impact do you think that's going to have both on the sort of business side, but also from a consumer lens, if you look at that?
Sure. Firstly, thanks for having me, Vishwam. And I'm sure I was hearing a little bit of what you had going before this, and it was pretty interesting. So I'm sure, and good luck for your series of such webinars. Regarding your question, I'll just draw out from where Vinita and Panduranga had spoken about certain clauses and certain changes, which actually includes a lot of people into this into the purview of such e-commerce definitions now. Fulfillment, for example, logistics service providers were carved out, so they. But there's also a certain clause which is particularly intended for logistics service providers. So, but in the entire ambit of e-commerce and how e-commerce operations take place, there are a lot of segments of play over there. There's payments, there's fulfillment, there's order processing, there's returns, there's call center, customer support service as well. Like Vinita had said earlier, whether it was going to be, so who all are going to come under the ambit of this? And the problem is, once everyone is vaguely inside this net of e-commerce, definition, what happens is there's a lot of interconnected liabilities that everyone has with each other because of vendor partnerships and their agreements for services rendered for and on behalf of the e-commerce companies. So the e-commerce companies will end up facing a lot of I guess incidental costs, which were probably earlier not falling into that bucket, probably because there's going to be a lot of grievance addressal and things which were actually beyond their boundaries earlier, but now because of this entire fallback liability, it's coming into that. It's almost incumbent upon them now to take care of it as well. With that being said, I feel like there's definitely going to be an added cost, and e-commerce companies I've seen have been always trying to pass on the cost to the consumers as well, as much as possible. And because e-commerce is a very operationally heavy kind of operation. It's not like brick and mortar. There's going to be a lot of returns. Returns still amount to a lot in terms of the percentage of the GMV. That already has its own associated costs because it's got damages. Returns don't always come in. So 3PLs are also involved in that entire process. On top of that, you have things like these where fallback liabilities in case the products or the defective products or there's any kind of change in the product specification from what was listed on the platform, even though the seller is responsible and it's not being sold by the e-commerce entity itself. That means it's a marketplace entity. So those kind of issues will definitely have a certain cost associated with e-commerce firms, and how they're going to transfer this cost onto the consumer, or they're going to transfer this cost onto the sellers. It's to be seen. One easy way for e-commerce companies to do it is, in case it's a marketplace, factor that in and build it into the margins or the take rates that they have or the commissions that they have with the sellers, so that every time for this additional compliance burden or liability that they're facing, they can always increase their commission percentage by 2-3 percentage points, and that would probably help, because then that would then go on to have sellers revisit their pricing, so they pass it on to the customers on their seller panels. So ideally, everyone will try to subsume this cost into the product itself without making it absolutely evident that there's another line item and this is chargeable for that. But yeah, I do see that it adding a certain amount of additional cost eventually.
No, understood. Actually, thank you. I think that's very helpful. And you did mention about compliances in terms of, like grievance redressal and stuff. We're going to take that in sort of a little more detail. But just in terms of compliances, if I come back to you, Panduranga, can you tell us like what are the new compliances? Just quickly, I guess, for the benefit of the audience. Akshish talked about the impact. So what really are the new compliances that you see from a legal and compliance angle?
There are obligation for like in the rules there are sections where inventory based e-commerce will have their own section of compliances and their duties, and the marketplace e-commerce will have their compliances and their duties. Now this seems to be like excessive intervention into business, just merely looking at this language and the ask under the act. I don't know, like how it gonna fly, whether it still be valid under law to a Consumer Protection Act to go beyond the intent of the act to regulate how a business should be conducted by this company. So be the case, but the vagueness in the compliances are too high. This again, maybe because of lack of understanding how these businesses are operating. And I have seen over a period of time how these companies or these businesses evolve to make sure better consumer experience to the consumers throughout the transaction and post-transaction, which means once the customer have bought the product or services, how well the customer experience is going to be. This means these companies have been competing each other to make sure they could provide a better service to customer and make sure customer is delighted. Now, if the government says you have to do this, and these are the minimum criteria, and for example, what if tomorrow government says, you'll have to set up a call center and you'll have to address all the questions of the customer through call only. That is definitely not going to be a solution, because as a customer, I would never be comfortable, talking to a customer care executive. I would say, like, if you provide me a chat service, I will happy to chat. Right? I will be able to do something else and alongside chat and close my, get my grievance redressed. But I think the gist of it is to this consumer delight is core essence to all these companies, and those companies would have already anyways would have taken steps to make sure that customer complaints are addressed. There is still an option for the customer to go to the consumer forum to file complaint before the consumer forum and get their grievance redressed. And the constitution of these consumer forums are meant for that. Right? So I would briefly talk about the compliances. Firstly, I would talk about some appointment. Right? I'm just reading out. Number one appointment is Chief Compliance Officer. Right? Chief Compliance Officer for compliance of the acts and rules. Right? And this compliance officer shall be responsible for any non-compliance under the acts and rules. Right? So there is an amendment to this e-commerce rules in the 17th May 2021, and it is already effective, and where it is called as nodal officer. Whereas this means that there will be appointment number one, which is Chief Compliance Officer for the purpose of compliance under the Consumer Protection Act and the Consumer Protection E-commerce Rules 2020. And then appointment number two, the nodal contact person. This nodal contact person is meant for to provide 24/7 assistance to the law enforcement agencies for those information they might be requiring in an investigation. Right? So this means, obviously, like all these companies already have their nodal officer, because there was a compulsion, because these companies started receiving Section 1991 notice. They wanted to man those Section 91 notices, and they have established their, specific email IDs or an individual to deal with such matter. Now, Consumer Protection Act mandates that you should have a nodal officer who should assist the nodal office, law enforcement agencies. I really don't know like how it is like related to a consumer protection. Thirdly, the resident grievance officer, which is under the Information Technology Act, where these intermediary guidelines are already talking about it, right? So e-commerce rule says that you should also have a resident grievance officer who should be acting as a compliance officer under the Information Technology Section 72 compliance. That if there is that's an intermediate. The fourth one is the grievance officer. He is the real person who will really make sense for consumers, right? So this grievance officer would be the one who will be dealing with the consumer grievances, and his name and contact details have to be published, right? And also the grievance mechanism also have to be published on the platform so that consumers knows who's this person. These are all basically on the appointment side, and then another compliance is companies should have to make a best effort basis to work with partner with National Consumer Helpline, right? Now best effort basis has been removed in the proposal. They said you will have to, right, to assist the National Helpline, Consumer Helpline Center. Now there are options, like multiple options to the consumers. Consumers either can directly go to consumer forum, nobody stops. Consumer can write to
I'm going to deal with some of this in detail. Sorry, Panduranga, just to cut you off, because I want to deal into a little more detail. I think if you cover everything, then we won't have anything else to cover.
I understand. I understand. I think there are a few other compliances specifically which were not altered, which was as remained as it was earlier. Like for marketplaces, like ranking system, maintaining disparity, all of those will remain. So I'm saying when you have like 4 compliance officer in organization, I think you have a 4 extra headcount in the organization. That's simple as.
We've got a question from Vishwajit, I think. Maybe we can take that now. Vishwajit, do you want to unmute yourself and ask your question, or you can ask on the chat box? No, okay. Then I guess we'll move on and we can come back to Vishwajit's question. Thank you, Panduranga. I think that was quite helpful in terms of, you mentioned about, obviously, we've mentioned, a lot of you have mentioned about grievance redressal and consumer protection and excellent service. I'm going to come back to you, Vinita. Can you tell us a little more about this proposed grievance redressal mechanism, and how does it really differ from what exists presently in e-commerce companies, whether it's in marketplace or inventory-based e-commerce companies? Is it going to be a completely new mechanism that you see companies setting up? Is it just going to be renaming an existing mechanism? Because there are some very specific compliances which the government proposes. You need to acknowledge the grievance in X number of hours. There is an end long stop date in terms of when you have to reply by. So how do you see this playing out in practice?
Right. I'll have to, unfortunately, repeat some of Panduranga's points to address your question. So please bear with me. A couple of things on how this changes, right? And what the requirements of the industry players are. For instance, Panduranga mentioned the 3 officers which now need to be appointed. There is one personal liability hitched onto a chief compliance officer. A company will find very difficult to hire someone who will say, yes, I will work for you and I will be personally responsible for everything that goes wrong with the company. That's going to be a very tricky proposition when you hire someone. The second is the nodal officer who's supposed to be available 24/7. Now, this begs the question whether every e-commerce platform is involved in a business which requires this kind of support, right? Where there are trust and safety issues, where there are incidents, untoward occurrences, there this kind of support may make more sense. And absolutely, right, in those instances, the consumer and the customer must be protected. But must it be applicable across the industry? Perhaps not ideal. Also, all 3 layers of this compliance creates quite a difficulty in new startups who are trying to simply work out of a garage in all likelihood. There are 4 people. For them to start running a business with this degree of compliance is rather complicated. And let's not even get to the cost of this, because I'm sure I'll have to pay through my nose if I was a startup to hire a compliance officer who's willing to take on legal liability for that provision. Having said that, there are some things which haven't changed. So there are certain compliances when it comes to receiving complaints and responding to them, which are not new in this iteration. However, are they honestly complied with, agreed with by companies? A matter of consumers having trouble in getting their issues resolved. Definitely, there's a gap there. How do we address this? Having a grievance officer, having their details published on the website, again, not new. But now when you mandate that I must now connect this to the National Consumer Helpline as opposed to the best efforts, how many channels is a company required to address complaints from? Do I look at the National Consumer Helpline? Do I look at my grievance officer? Do I talk to my nodal officer? It becomes very unwieldy to run this sort of redressal mechanism. Having said that, it's not untrue that there is robustness required in dealing with consumer complaints. There is a certain laxity in how consumers raise their issues and get a redressal or don't. They have to end up in a consumer forum, which is an additional cost, and perhaps not all consumers have that sophistication to go and approach a consumer forum or the deep pockets to appoint counsel. So there are issues that need to be addressed. But is this the best way of doing it without looking at specific market practices, specific industries, and whether this will, in fact, in the large scheme of things, significantly hamper ease of doing business if it's not customized? But to make a long explanation a little shorter, how has this changed? Not significantly, other than appointment of the officers, because companies were always required to have a grievance resolution policy, display, deal with it, etc. So from what companies were doing in the past, except the appointment of officers, no significant or very cumbersome new compliance has been introduced when it comes to grievance redressal.
Thank you, Vinita. I'm just going to come back.
Just to add what Vinita said, they were already cumbersome, so therefore they didn't make it even more cumbersome.
Perhaps.
I'm going to come to you, Akshay. What do you think is the sort of commercial angle to all of this? So Vinita said, there's already like grievance officers before. It's just putting that information on the website now. Is that your feeling as well, or do you think this is like a completely new exercise that you have to do now in terms of appointing grievance officers, a grievance process, and then integrating with the National Consumer Helpline?
So yeah, there are a lot of things to this. Firstly, it's when you say with all these additional compliance, what also has to be seen as each of these compliances are not easy to like just roll out. Having 3 individual instead of 1 looking at, say, all of this compliance or grievances is obviously going to add to costs. And there are a lot of mid-sized or small companies that are also going to come under the purview of e-commerce now, e-commerce definition, which may not be able to afford this. So then the question arises is, can you have the same person but have the same contact under these 3 different roles? There are a lot of such things that will arise because it's impossible for e-commerce companies that are small to have all these kind of compliances in place without somewhere rationalizing their costs. And that's going to be seen as one of the largest most cumbersome issues with this new set of amendments that's proposed, because in my opinion, commercially it's not really viable for small companies to have 3 officers for this, almost for the similar kind of role, which is just not subdivided into further roles. Secondly, like it was mentioned earlier, integrating the National Consumer Helpline with your own customer channel, customer support channel, that's not an easy thing. It's hard enough that there are already so many channels of customers reaching out, and companies, e-commerce companies especially, having to be in touch with customers on each and every single channel, and hence feedback is coming from each and every single channel, and all of that needs to be collated. On top of that, there's one additional channel now through the National Consumer Helpline, through which the e-commerce companies will have to like review, provide feedback, or settle grievances. And in other words, it's just an additional ticketing channel. And I don't believe National Consumer Helpline has gotten that level of tech savviness today to just integrate with current systems that e-commerce companies have, where the rest of the channels are being integrated. So again, big companies, they can probably do it. Small companies, already it's a big challenge with so many channels, and then you're adding one more channel. Again, it becomes a big, challenge and a problem for them. And like it was mentioned earlier, I mean, whether it needs to be a resident grievance officer, or it's possible for outsourced third-party grievance officer, that is also not clearly mentioned. But I'm sure that a lot of such e-commerce companies, or the ones that come in the purview of e-commerce definition now, will probably use freelancers or third-party vendors to play the role of these individual grievance officers and the new roles that have been recommended.
Okay, interesting. Just this, so I guess your position is that you can probably outsource these officers to whether it's freelancers or law firms or stuff. I just want to bake into here, I think, what the other panelist position is, because obviously the rules are not expressed on this. Maybe just very quickly, Panduranga, do you think e-commerce companies can outsource these rules, or they have to be employees?
Yeah, the nodal officer and the chief compliance officer have to be resident of and should be Indian citizen, and also employee of the company.
Okay. So you can't sort of engage a law firm or a freelancer like Akshay is saying to act as your compliance and nodal officers?
No, that is so. Engaging third parties could have been cost effective and more efficient for a small company. I probably think government should reconsider this, because the current proposition is that they should be resident and citizen of India, and also employee of the particular organization who appoints them as their compliance.
I mean, it's always possible to have a contract employee, which is in a way, with a certain SOW or scope of work, which can include this nodal grievances and as a nodal officer.
Yeah.
So it's kind of, unless it's really clear that he needs to be an employee with the company, with drawing the PF and all those things, it's going to be a gray area.
I agree.
When you say can it be a full-time contract basis for part-time employee? Then when the question is like whether such employee is being hired by you on a contract basis, on a full-time, then I think there should be still an opportunity for you to negate this requirement, because that individual is like fully employed, but now really not helping in any terms of reducing cost, right? Because either you hire people on your roles or on a contract role, you still have to spend that monies that you are supposed to be spending. Assuming you have an opportunity to use a third-party service provider who could be providing services to multiple small-time e-commerce companies, then you will be able to receive such services at a very economical cost. I'm talking very economically here, how it make economical sense for this startup. I'm not expecting any startup at the beginning to focus on business, rather like spend all their monies into compliances. We are not talking about other compliances, right? The Companies Act compliances, it's always outsourced. Your regulatory compliances outsourced. So we need to think something innovative, maybe at least create a threshold, significant e-commerce company or non-significant e-commerce company, something like that.
I know you're borrowing a lot of terms from the information technology rules on the Ranga, but I think if you look, I'm not trying to advocate an advocate for MSMEs, but I think the MIBs received, I think, registration from about 1,800 publishers A lot of them are actually, like 2-man, 3-man armies. And they've actually set up grievance redressal mechanisms. I can't speak for how much cost they've incurred, but I guess there is a case to be made that if digital publishers who are literally 2-employee companies can do it, then an e-commerce company, which is a much bigger operation, should definitely be able to do it. Obviously, there are arguments on both sides, and I by no means mean to go into the debate, but I just wanted to sort of throw it open in the audience so sort of people can think about it. I do
More
want to
about no, I think just to kind of wrap, tie a knot on that discussion. I think the issue is not about have there being a mechanism in place. I think the issue is more about what are the pillars of that mechanism and are they doable?
Yeah, I second that. I think that's one of the biggest challenges because that's not been clear. And what is it going to rest on? The whole set of compliances. Where is the body that's going to regulate that? Is there a guardrail along which the nodal officers are supposed to ensure that the companies run, or is it just a nominal role which is not really meant for? Or there's no cross-checking unless there's a flare-up.
Yeah, no, I agree with that. I'm going to move on now, and I'm going to take. I know Rakhi's Banerjee. Thank you, Rakhi. You sent some links here, and she said all the customer service executives / internal grievance redressal, I imagine persons are trained to give robotic answers. But I'm going to use this to sort of throw a question out for the panelists. If I were to be, the consumer advocate, and I say, there are multiple channels now. There is a grievance redressal mechanism proposed, mandatory integration, the NCH proposed. There's obviously the consumer courts and everything that Vinita and Panduranga mentioned. So there are a number of channels, and that may completely increase compliance. That's a fact. I guess no one can disagree with that. But what happens when these channels don't work? So let's take it step by step. So Vinita, you have tomorrow set up a grievance redressal mechanism, or any e-commerce company has. Rakhi was to send you a grievance. She does not get a response and acknowledgement within, say, 48 hours, or her grievance is not even responded to in the next 60 days. What then happens to e-commerce companies? Is there any penalty you see on e-commerce companies, or is Rakhi's only recourse is to really go to either the NCH or consumer courts and other fora?
At the moment, Rakhi's recourse is to approach the next fora. Absolutely. There is certainly a requirement to tighten that, but also to address Rakhi's question on there being robotic answers. I think any consumer redressal facing mechanism needs to be standardized to a certain degree, because it would be very convenient to hope that if Vishwam called any company, he would meet a friendly face called Vinita, who will now sit and talk him through what his issue is and solve it for him. But that's not how a mechanism would get built. The people who would address would not be the people running the business, because they have a job and they can't stop their day job and start doing consumer calls. So there is a reason that it's built a certain way, and there is a reason there are appeal fora for that when that doesn't work. And that's not unlike any other mechanism outside of the consumer space as well, right? Every litigant, every petitioner, every applicant is given these options when the other party is not reacting. And if the other party is being completely unreasonable, any district forum court will take that into account when it decides to pass an adverse order, for instance.
Thank you, Vinita. I'm going to come to you, Panduranga, now. In that situation, assume that the complainant did get a response from the grievance officer. Whether that was satisfactory or not is a moot point. Do you foresee that now the consumer courts are going to sit in some sort of appeal or review of the decision of the grievance officers? Do you foresee that happening, or do you think these processes sit completely independently? So if the complainant is not happy with the response to the grievance officer, the consumer court is actually going to have a fresh start?
I think the very question of this redressal mechanism established by these e-commerce companies is to possibly redress all the grievances of the customer, and there will be a finality of the matter. So there is an opportunity created for the consumer to, impress their issue with the respective seller or the marketplace platform, so that they would look at resolving those grievances. At times, there will be like time-bound responses, acknowledgement, and redressal should be issued within certain days. But not always those redressals be satisfactory to them. So consumer, if you were to like consider this as an opportunity as first level of dispute resolution mechanism, the complaint is effectively means to be an appeal, but under the Consumer Protection Act, that is the first step for the customer to file a complaint against the parties against whom they have grievances for a redressal. So the redressal begins at the judicial redressal begins at the consumer forum, and you can't be like expecting the e-commerce company who their nodal officer is their own employee, and he is adjudicating for the company and the customer, would be most of the cases be fair to the customer. Right? That's the general perception. So in this context, I would say by opportunity wise, it looks like an appeal, but as a judicial adjudication of a consumer redressal will begin from the.
Thank you, Panduranga. I'm just going to move on. There are a number of amendments in the e-commerce rules which talk about advertisements and like fraudulent advertisements, talk about like misleading advertisements, etc. Generally, I think advertisement grievances, historically at least, have been quite separate. The Advertising Standards Council, as a self-regulatory body, has been looking at them and then passing decisions. And they've been coordinating with the Ministry of Consumer Affairs. They have their GAMA portal. I'm going to come to you, Vinita, because I know you've dealt with some advertisement grievances. What do you think is going to happen now? Do you foresee advertisement grievances coming to the e-commerce companies under the new grievance redressal mechanism? Instead of going to ASCII, do you see these as parallel processes? How do you foresee this happening?
Okay, so the restriction on an e-commerce entity is the fact that it must not have misleading advertisements, right? That's the primary obligation on the company. Where these are, let's say, consumer facing and they have an issue against advertisement, the consumer has the liberty and the option of approaching ASCII. They take three kinds of complaints as a self-regulating body: suo motu, industry, and directly from consumers. So that option exists. They have a very clear mechanism. They have an internal counsel which will examine the issue and then provide whatever redressal they need. However, in my understanding, it is very rare that an average consumer even realizes that they have a forum called the ASCII to go to. The reason that we know this is because we, as in our careers, in our jobs, we have faced complaints or issues where ASCII has been involved, or we read about them because that's our job. But I don't think the average consumer knows this. If they were to know it, can they approach ASCII? Certainly. However, at the same time, if they have approach a district forum, for instance, putting aside the company's internal mechanism, ASCII will not entertain matters which are already in court. So can they approach both in parallel? Unlikely. Can they go to the company and to ASCII? Sure. In entirety, how many forums is a consumer reasonably expected to approach? Right? There's time, there's money involved, but that option exists, certainly. But I've seen ASCII to be more active on a suo motu front, and it's very rare that consumers have taken that approach as opposed to a forum or internal complaint mechanisms.
Thank you. I'm going to come to you, Akshay, on the same issue, just to understand it from a little more sort of commercial angle, a little sort of non-legal angle. Advertisement is growing on e-commerce companies. If you look at the recent statistics, is advertisement on e-commerce quite a big market, and do these amendments in that way make sense for the e-commerce companies to deal with advertisement grievances?
So I'd like to understand your question a little more, if you don't mind.
No, please. So I mean,
referring to advertisement on the e-commerce sites, or are you referring to as advertisements by e-commerce sites on, say, different media?
no, advertisements on e-commerce sites.
Right. So, in my opinion, advertisement on e-commerce sites has definitely been it's not so transparent. You have advertisement on e-commerce sites where quite a few, and now e-commerce has gotten larger in terms of its definition, and hence the purview of e-commerce sites will definitely garner a lot more URLs, or companies that are doing a lot of different ways of advertising. There might be short content, there might be like banners, there might be just promoted listings or sponsored products. All of those things, unless there's a transparency in the system that, say, a so-called consumer is known or is made, it's made clear to him. It becomes really difficult to from the consumer's side to like trust the brand or the company in a way. I would give you an example. If I'm browsing on a site and if I'm seeing a sponsored product right before the most popular listing, and the popular, say, suppose the listings are being classified by default, they've been sorted by popularity. Suppose this is sponsored listing before the first listing, which is often the case. Now that sponsored listing, without actually having a sponsored tag, is kind of misleading to the consumer. And I mean, like, in a way, I don't think this comes under the realm of ASCII, because ASCII is more like a body that looks at non-digital or non-performance based advertising, which is more towards brand marketing and ATL activities. So I don't know how much of this kind of advertising and having a uniform advertising policy for this kind of e-commerce advertising, whether it will do any good for the consumers if ASCII was to take responsibility for it.
Okay, understood.
If I may add.
Yeah, go on, Panduranga.
So ASCII primarily would deal with all those misleading advertisements to remove or call those brands to take off those advertisements. I think so that no further damage would ever happen by misleading. But like under the Consumer Protection Act, misleading would really mean someone have to suffer injury or losses because of a misleading. So for there arises a consumer grievance, and there is a redressal requirement where such customer will be entitled for a compensation. Right? So there will be a monetary impact on those misleading advertisers on this platform. Now the risk is the lines are not so clear in this, for these e-commerce companies. They cannot determine as to advertisers' responsibility cannot be attributed onto the marketplace or a platform. So that's the point I wanted.
Thank you, Panduranga. Just while I have you there, I'm going to touch another very important topic. I think logistics service providers. How do you see grievances against them being filed? If someone has a grievance against, say, the logistics companies, do you see that going to the e-commerce companies now, and then the e-commerce companies being like a sort of channel between the complainant and the logistics service providers?
Yeah. So generally what happens today is e-commerce services are mostly provided by those marketplaces, or those e-commerce sellers selling on this marketplace. So this essentially means they might want to deliver it by themselves. They have an option, Few of them provide those options. Few may not, because of they feel those will not really help consumer, help to give consumer a better experience. Now customers are expecting the product to be delivered to them in a day, or same day, kind of services. Then that is only possible by providing logistic services by these companies, by setting up their own warehouses where they provide or lend spaces to these sellers to store their inventory, and therefore all these packing to delivery services are provided by these e-commerce at a nominal charge, or maybe whatever the charge. Now there is no discrimination. There shouldn't be any discrimination in those prices of those delivery services. All right. Now the question is, like, for those issues with respect to the logistic service provider, then where should the consumer go to? It is today e-commerce companies. If the government were to like tighten more and make sure that these e-commerce companies are held liable, then probably they might start disintegrating these services and tell the customer, you directly avail services from this logistic company. You don't feel like happy with the services, go sue the logistic company. This is also not really helpful for the consumer. This, if I were to like think, if this is an approach that e-commerce companies were to take. So otherwise, these logistic services are still being provided by these companies, and therefore these services are under the special programs. There will be subscription program these marketplace companies run, under which deliveries are free. Right? There are no charges. Right? Be it food aggregator, be it marketplace companies like Flipkart and Amazon. For example, if I were to say, if you are a Prime subscriber, you will get deliveries at no delivery charge. So is the case with all the e-commerce companies. They run these programs so that the customers get benefited and customers stick to this plan.
Thank you. I'm going to come to you, Akshay, now on the same issue, because I imagine you have a lot of practical experience dealing with logistics service providers. How do you view this sort of situation from a non-legal, sort of more commercial angle, in terms of e-commerce companies having to deal with grievances against logistics service providers, and how do you think commercially it's going to sort of change the market, the e-commerce market in a way, or do you think it's not going to have much impact at all?
Yeah, thanks for addressing this to me. I had something to say about this, and taking cue from what Panduranga said. See, these logistic service providers that e-commerce companies usually use are, in a way, just a vendor performing a task on behalf of the e-commerce entity, of the e-commerce company, and in most cases, the consumer is only looking at the e-commerce company as the front. So what happens is, suppose I have a shipment coming from XYZ on website, and my claims, my concerns are all going to be directed towards mostly the e-commerce company, and then second the LSP, or the logistics service provider. The logistics service providers redressal, or the grievance that is intended towards any LSP is most likely going to have some sort of, I'm not sure whether the law is clear about that, whether it's going to have any kind of fallback liability on the e-commerce side, because ultimately the law states that there's going to be some sort of fallback liability on the e-commerce, not just for the sellers, but also the partners. So one of the partners of the e-commerce sites are these LSPs, even though there's a carve-out specifically for LSPs. So if that's the case, e-commerce companies will try and, they would try and decouple themselves from these LSPs, which means that they would probably try and provide consumers a choice for which LSP to choose, and then in case the consumer has chosen a certain LSP, those kind of queries and redressals can be directed towards that LSP. When an e-commerce company does not give the consumer an option to choose for the shipment or the 3PL or the LSP that's used, then it's kind of taking the responsibility and the onus of addressing all those grievances themselves. But if they give the option to the consumer to choose and select in a way, then that can be, decoupled from the e-commerce, and then they can minimize that fallback liability. In that case, I would believe that it would. So that's the reason I said, taking a cue from what Panduranga said, I believe that would then lead to certain forms of LSP subscription, which has not yet really come from the consumer aspect, except for an Amazon or say, Prime, for example, where you are kind of subscribing, but you're subscribing for that kind of 1-2 day delivery service. But in case individual e-commerce sites do that, they can offer similar things, which is actually a package on the LSP side or the logistics service provider side, and depending upon who the consumers are confident about, they can go for that particular subscription, or and then hence use only those LSPs, and then the entire onus of clearing any kind of tickets or redressals, grievances would then be with that particular the LSP that is the beneficiary of the subscription.
And that's certainly very interesting. I think it raises a number of issues, but I think we probably want to go a little away if we get into that. I'm going to come to you, Vinita, now. And I think just because we dealt with grievance wrestle in sort of quite in detail, I think we missed one point, and I wanted to get your thoughts on that. So direct sellers, as far as I understand, also need to have a grievance redressal officer and a mechanism. How do you see that playing out on marketplace e-commerce companies? If I were to file a grievance against a marketplace e-commerce companies, is that then going to be redirected to, say, the grievance officer of the seller? Or do you think complainants are directly going to file grievances to the seller who actually sold the product or the service?
What they will do and what they can do are perhaps two different points. I think they certainly can address a direct seller, and that officer will have to address it. Who this direct seller is now going to be a question of whether he falls on the revised definition of e-commerce entity, or whether it's a direct seller, literally a shop, a brick and mortar store. But what they are likely to do is approach the e-commerce platform, because that's the lowest hanging fruit. That's the first step that they interact with. Also, because an e-commerce platform as the intermediary does a lot of complaint management, payment processing, etc. So the natural course, the natural recourse would always be the e-commerce platform. Even if today, we've touched upon this very mildly before, but while the customers should and the consumers should have that access, and in their minds, perhaps the structuring of a seller versus a marketplace versus an inventory model are not clear, and they should be able to approach an e-commerce platform in itself, but the platform should be able to move them on to the actual entity carrying on the selling or the services. Because if we merge the two, the sanctity of an intermediary model falls away. Then there is the whole idea of having an intermediary, the whole business concept of having technology being the selling point and allowing traditional sellers and service providers to merge completely gets destroyed, and which has been recognized in some form in the FTI policy. And they're, of course, addressed to different problems. The mischief each law is trying to avoid and trying to prevent is different. However, at some point for the e-commerce entity, they'll have to marry, because I cannot be in a position as a company where I'm afoul of one constantly and aligned with the other. So there is that tricky bit about how this will actually pan out in practicality.
Okay, just taking us a step further. If I was a consumer and I file a grievance against a marketplace entity, and the marketplace entity's grievance officer forwards it to the seller's grievance officer, copies me in, and says he's going to deal with it, I've washed my hands off it. Do you see that practically happening and being acceptable?
Two things. Currently, in the form the rules sit today, I can't do that. The marketplace entity can't ignore your complaint or move it on. Traditionally, if in the absence of these revisions, that will not happen because there is a trust element. And I think Panduranga used the perfect word called customer delight, which every player in this ecosystem is quite focused on. So practically, that's very unlikely to happen, that entities will step away from their primary customer. But will on paper that liability be split? Under present law in place, yes.
Okay. I don't know if Panduranga, you or Akshay, you have anything to add on the sort of.
I have. So Akshay, you want to go first? You can go.
Yeah, sure. I mean, like, now one of the things that I felt about how, you know, any kind of these online disputes can um, roll over into like, and directed towards sellers on the intermediary or on the intermediary entities like the marketplaces. Whether or not that's going to like fly in terms of the current law, I don't think it flies. Whether people are doing it, I believe that there are still some companies that do that, and I'm not going to name any, but then it's very different because there are different kinds of grievances that consumers can have. There might be some warranty issues. Warranty issues are always then subordinated to the respective sellers or the brands of the sellers, where the intermediary themselves is really just directing or connecting again, and that's the best that it does. So where there is a clear line between an e-commerce entity or an e-commerce marketplace, whether it's just an intermediary or it's an e-tailer, and it's got its own vendors, because even e-tailers has got its own vendors, and a lot of times e-tailers themselves have the vendors inventory sitting in their own warehouse, but they're selling it as if they're the ultimate entity invoicing the consumer. In both these situations, there has to be a clarity as to who or which entity is going to take the burden of compliance, especially for solving any kind of grievances. And I believe unless this clarity is there, it becomes really difficult for any consumer to be clear and hence gain the kind of confidence or customer delight that almost all such e-commerce entities now are looking for.
Thank you. Panduranga?
Yeah, well said, Akshay. See, the position is very clear. Like Vinita was arguing, I am an intermediate. Intermediate position should not be taken. It will be very murky if intermediary shall like step into the shoes of a seller. But the courts have, the consumer forums have been taking a different. These consumer forums, I think I am not recollecting the judgment, but it is as old as a decade old, where e-commerce were not so known to everyone. There was one VCP related case where the customer went to consumer forum. Consumer forum, the case filed against the seller of the product, not the manufacturer. The court, the seller argued that I am not the manufacturer and therefore I shouldn't be held responsible. The warranty is issued by the manufacturer and the service center is also operated by the respective manufacturer. So I shouldn't be held responsible. The court felt whatever so, you should still be the point of contact. Customer has come to you to buy the product. You deal with the manufacturer. It's the same logic is applied. The fallback liability is also some sort of same approach that consumer this proposed amendment trying to solve is to, if a customer is going to a particular platform to buy a product, they are going to that platform for the brand name of that platform and also expecting certain services, quality of services or a level of services from that platform, right? I'm not taking the name because it's going to be so not so nice. But if I may have to make a choice between two service providers, I feel like a service provider A would be the better service provider, and hence I would be making purchase from. Now, the seller is not so important or a material for me, right? And therefore, the logic of fallback makes perfectly sense in these cases. So therefore, if a customer have a grievance, have a product issue, I mean, obviously product liability cannot be ever attributed to the intermediary. But I think in all these cases, if the customer issues has to be redressed, the intermediary should step in and do something about redressal so that customer problem is resolved to the satisfaction of the customer. Otherwise, if the e-commerce cannot take a route of like, hey, I am not responsible, you just go to the seller, you just go to the service provider, then that may not really work, because at times these e-commerce companies also hesitate to share seller details, contact number, person name, nothing is available.
Thank you, Panduranga. I'm going to moving on to the last theme of our panel discussion today. And I want to discuss online dispute resolution and what potential it holds in light of the new proposed amendments, specifically for e-commerce disputes. And I can see in the audience a number of people who actually have had experience resolving disputes, online mediation, arbitration. I'm going to come to you, Vinita, first. We have the consumer courts. That's always been there since the Consumer Protection Act was there. We've got now the formal grievance redressal mechanism. There are obviously consumer centers and helplines and the NCH. If you ignore the courts for a second and say a consumer grievance is not redressed, a problem is not being redressed, do you think it's an opportunity for e-commerce companies to resolve those disputes online, whether it's through mediation, conciliation, arbitration?
I think it's certainly an opportunity for the market to start addressing these concerns through pre-litigious measures. And arbitration, conciliation, mediation are certainly something that should be explored, because very often a matter ends up in court because the customer is dissatisfied and they've not been given due attention and time to resolve their matter. Having said that, whether e-commerce entities independently, each of them can build this mechanism, that would be a very tough call. I mean, there are countries where the national or the state-run consumer forums are the ones who mandatorily require mediation and arbitration. So with a certain amount of support from the system, from the state, I think there is a huge potential for e-commerce entities to be able to partner with that sort of a state redressal forum or capability and explore this route. I think from an entity perspective and a consumer perspective, avoiding courts and coming to an agreement before that is in the best interest of both parties. It's a win-win. So the potential is immense. The burden, however, will be very difficult for individual companies to bear.
Understood. I'm going to come to you, Akshay. Would you rather spend money resolving disputes online on arbitration mediation, or would you prefer to prefer the disputes go to courts across all parts of India?
I believe that it's not going to be practical or feasible for every such grievance to go up to that level, and hence there has to be a simpler way. And like at the beginning, when there was I think there was a question from the audience that everything is like boilerplate in terms of a response. The reason that is required is, if you want to scale, you need plug and play. You cannot have customized responses if you're going to scale something. And the more data any platform, any e-commerce entity is able to aggregate, the more it's able to know the different kinds of grievances, and hence it will go on doing that. And that's the only way to scale. And that scale will enable shortening the process or minimizing the number of cases that actually get escalated to that extent, where you're going to end up in court. So I don't believe that, and I wouldn't want every, case or instance getting escalated to an extent where one of our officers have to go to the court. But being able to offer a very scalable and a very concise, solution for these grievances at a particular level, and solve all of it is going to be a big market if all of these rules come in. And I do see that there might be a lot of innovation in that space, even more than what's happening today.
Okay. So sorry, just coming back to the question. So you would rather to have it solved online or go to court?
Of course, any day. I mean, we cannot afford going to, I don't think a lot of people will be able to afford going to court for every small consumer duress. So my point was like, it's necessary to have plug and play and, boilerplate responses ready. And that's like first level. And with the help of that and these online systems that can help, address all of these grievances, we can minimize the number of times we actually end up going to court. And I think the number of instances of people going to court will reduce if the number of people assuming this online redressal mechanism will increase. So I think there's a lot of scope for that in times to come.
Okay. I'm going to come to you, Panduranga. What are your thoughts on online dispute resolution for e-commerce disputes?
I don't know, like, what it's gonna be. There are a lot of opportunities available at this point in time. For example, if I were to say online dispute resolution as a tool-based solution is also possible, where you will have an arbitrator who would be independent offered by the service provider. Could be a great option, but that doesn't eliminate that will create one more option to the consumer. So there will be some amount of a transparency for the customers to believe or be satisfied of how a third party individual thinking about money before going to the consumer forum. Will that eliminate his choice to going to the consumer forum? It is not. Now, who will be really willing to spend that cost is the question. If a customer is willing for that cost, probably e-commerce companies may happily provide it. And if e-commerce companies have to take that cost, I think they've already taken so much of a cost from seller to consumer perspective. I think it's going to be too much to ask from an e-commerce company. So online dispute resolution, probably when these consumer forums operate on a online manner, probably that could really help these companies. Also like provide customers a quick resolution. Right? They wanted to resolve the matter as fast as possible. I do agree with most of the consumers, and as a consumer, I would also feel, what if my transaction can happen in a day, but my dispute will be resolved over 12 months? That's really not okay. It's a long way to go. I really not have a convincing answer today, which makes me feel like comfortably, yeah, this is the right answer.
Okay, understood. I think that's it really. I don't know if anybody in the audience has any questions. Maybe we can take them now. But otherwise, I can see on the clock we've got 10 minutes. Maybe we can have probably, if there are no questions, we can just let each of the panelists conclude in sort of 3 minutes each. If there are questions, then I guess I'd prefer to take them. Maybe we start with you, Anita, and in 3 minutes, if you could conclude any final thoughts.
No, sure. Thank you, actually. Thanks very much for having me on the panel and to be able to address the audience. I think it's a privilege to be able to discuss these matters with people in the industry and in the stream. So thank you very much for that. Generally, I think the comments that I would like to make towards the end is these are very interesting. The changes that have come in these draft proposed rules are interesting. They indicate where the market is headed, where the regulator sees there are gaps in the system. Ideally, they should be in a place when they are finalized where there isn't confusion in their implementation and the interaction of the other laws. But the intent is obviously sound, and that intent should just get fleshed out and implemented in the right form. We'll have to wait and watch, but I think a lot of entities today and lawyers, business people are looking at these rules wondering, how am I going to incorporate this into my systems? So I think as quickly as that ambiguity is gotten away with, we might actually have more peaceful nights.
Thank you. I'm going to come to you, Panduranga, next, and then we can have the sort of non-legal side from Akshay in the end.
Yeah, thank you. So I wanted to just give away my disclaimer at the beginning, but I'm giving it away now. So whatever I said was my personal opinion. It has nothing to do with the company. So I would see this from a intent perspective in right direction. But I could see, to my dismay, there were a lot of clerical errors in the proposed amended document. Probably government and the bureaucrats would really now, policymakers specifically, would go back and review these languages and figure out what they wanted do to achieve objectively what they wanted to, and reduce those interventions that they have created in these rules towards the business. I think that will be a great help for this ecosystem, specifically for e-commerce. And generally, if my point of view is, if government, if the rules are so you know, rigid for these e-commerce companies, and when obviously under the guise of consumer protection, but what is that they are doing for the offline sales of offline transactions? Like, all this can happen offline also, but it's only change of mode or channel. So therefore, there should be some parity has to be drawn. Otherwise, it's gonna really help to protect interest of consumers who are dealing only online, but not for offline. I think this could be now looked at as a disadvantage to e-commerce companies, but actual disadvantage would be for offline, because consumers tend to interact with online transactions more.
Thank you, Panduranga. Akshay, sort of 3-minute conclusion and I guess final concluding remarks.
Yeah. Again, thanks for having me, Vishram. Again, it's like it's great to hear from the legal perspective. Even I'll have to go back to my legal in my company when all of these things roll out, and we'll have to figure out a solution. But in my opinion, from a non-legal perspective, and just from how it might affect operations, and what all new responsibilities might crop up for e-commerce companies to adhere to. I believe that though the best of the intent is there in these new amendments, especially for in when you take it from a consumer perspective, I do not think that it's made the job of e-commerce companies easier, to be honest. And again, like a disclaimer, it's just my opinion. I don't think e-commerce companies, unless they are able to identify where the boundary or the line ends, it would not be easy. Forget easy for the e-commerce companies to take end-to-end responsibility. It wouldn't even be easy for the consumers to have clarity as to who is going to be responsible and who do they address in order to come to a solution or get some sort of resolution. And that kind of ambiguity, if it can be put away, it can at least lead to certain it will ease the rollout from these e-commerce companies side in adding such compliances and compliance officers and compliance processes. However, I do believe that a little bit of gray area needs to be bridged, and it's better to have a very clear boundary between where do the responsibilities end between service providers and e-commerce entities themselves.
Thank you, Akshay, and thank you to all the panelists. I think it was quite an interesting session, and I have certainly learned a lot from it. I'm hoping the others have as well. So just sort of final in terms of logistics for our attendees. As always, the recording will be available on YouTube. And our next webinar will be, as it's usual, the last Friday of August. So we'll come back with sort of more updates and a sort of new panel. And I would just request Chaitanya now to sort of thank the panelists and conclude the session.
Thank you, sir. So participants, this brings us to the end of our today's session. On behalf of Team Corporate Law Advisor and CII, I would like to extend a special thanks to our panelists, Vinita ma'am, Akshay sir, and Panduranga sir, for being a part of this session and sharing their wisdom with respect to this important issue and discussing this issue both from legal and non-legal angles. So participants, see you all in the next session with some other updates and discussion on important topics. Till then, goodbye, take care, stay home and stay safe.
Thank you, Vinita, Akshay, Panduranga. Thank you.
Thank you.
Thank you.